Hi everyone, thanks for coming to this panel. I'm Lorenzo Franceschi-Bicchierai. I write for Motherboard, the tech and science channel of Vice Media. I'm really excited about this panel. We have a lot of things to talk about, so hopefully we can go through the main issues, and since this is a very complicated topic, I hope that we can open it up to everyone to ask questions, and no question is too stupid or simple, so please feel free to ask questions, and we'll try to keep it friendly here, and all of us can jump in whenever we want. Just as a little bit of an introduction, we're going to talk about basically how governments hack, how governments use hacking. Some people call it lawful interception, some people call it spyware, Trojans, surveillance technology. It's all part of the same thing. So in practice, we're going to talk about how governments use hacking techniques and software in the course of intelligence and criminal investigations. So we're not going to talk about the classic cybercrime, teenage hackers stealing credit cards. We don't care about that today. So this is a thing that it's been going on for a while, I think 10, 15, maybe 20 years. Governments around the world have started using hacking to catch criminals, terrorists, and others. But for many years, the public hasn't really known too much about it. In the last few years, we've known a little bit about it because of public research into companies that sell these kind of tools. For example, the famous hacking team. And so we've seen a little bit about how these things work. Also, we had obviously the Snowden revelations, which gave us a little bit of a window into how the US government does this stuff as well. So why do governments use hacking? We're going to talk about that, and we're going to talk about how encryption technologies and the rise of high-tech encryption technologies has pushed governments to do a little bit more hacking. This issue has obviously two sides, the technical and the legal side, and luckily we have here people that know a little bit about both. We have a tech person, a lawyer, so we'll hopefully talk about both. And obviously this is a very timely moment to talk about this because some Italian parliament members have introduced a law to regulate hacking in Italy. So we'll talk about that too. But first, let me introduce my colleagues and friends here. We have Stefano Quintarelli here. Quintarelli, I don't know how to pronounce it in Italian or English. Anyway, he's a Scelta Civica member of the Italian Chamber of Deputies.
That's a fake news.
Fake news, great. A graduate in information science from University of Italy, of Milan, sorry, and he's one of the pioneers of the internet in Italy. We have Valerio Lupi here. Valerio has worked as a developer of government surveillance software or lawful interception since 1998, which sounds like a lot of time ago. He's a former rootkit contributor, which at the time was the reference website for what people call now advanced persistent threats, or APTs, basically like high-level hacking. We have Giovanni Battista Gallus, who is a lawyer specialized in copyright, criminal law, data protection, and privacy. He has a European certificate on cybercrime and electronic evidence. His resume and curriculum is probably too long.
And too boring as well.
No, not boring, but too long to go through. And we have Carola Frediani, who is my colleague, journalist from La Stampa. She's also the co-founder of the media agency F5, and she has written basically about all, she's written about hackers and all kinds of spyware and surveillance stories. So thank you all for being here. But let's start with the obvious question that probably everyone has is, what is government hacking and why is it controversial? And maybe, Carola, you can start telling us a little bit about that.
Yeah. Oh, thank you, Lorenzo. Did you present yourself?
I did.
Okay,
I'm just
okay. Lorenzo,
so.
Is also covering a lot this topic. So Yeah, as you said, it's been for many years government has been using these tools. I mean, but we really knew little about them until a few years ago. And I think there's been like a public instance of this. It was around 2001 when we talked about, remember Magic Lantern? This was the code name, the name given by the media for an FBI tool trying to capture, passwords. And then later on, much later on, really the topic came out. I think the year was 2011. It has been a kind of crucial year for the public awareness because we had the Chaos Computer Club found evidence of a Trojan used by the federal government and in Germany. In Germany, the Chaos Computer Club is this, well-known hacker groups in Germany, and at the same time, WikiLeaks came out with these spy files where some producers were named among other surveillance or lawful interception companies, and also in Italy we had maybe for the first time on the mainstream media at least there was the news about this tool being used for a specific inquiry. It was if you remember in the so-called P4 for the Italian, investigation, and it was, it came out that, they use it. But actually, I have to say that the interest really grew after the leak of Hacking Team, maybe because it became so mainstream that all the different aspects of the issue, because as you said, it's a very complex issue because it has different angles. Of course, in the last years, it's been covered a lot about the use of these tools to, especially in foreign countries, in non-democratic countries, but and this is like an export issue. But then you also have the use in democratic countries. How do you intend to regulate them? Because and now we have a lawyer, we have a legislator. We know that they have not been regulated really at all. There's a sort of a limbus, not really a defined status. So yeah.
Yeah, I think the regulation is a very important point, and you mentioned Germany in 2011. I think Germany at the time became the first country to pass a law that specifically talked about Trojans. I think they called it the Bundestrojaner law. Yeah, and as far as I know, very few other countries, or maybe no other country has a law specifically that talks about Trojans. And Italy wants to be the next one. So maybe, Stefano, you can talk a little bit about this proposal that you guys have, and basically tell us a little bit about what you want to do and why now.
Okay, thank you for having me here. Well, effectively, grazie. Effectively, slightly more than 2 years ago, sorry, I have to apologize. I have a train to catch, so I will have to leave 15 minutes in advance. I apologize with all of you guys. Something more than 2 years ago, there was an amendment passed in the Chamber of Deputies which gave essentially the possibility to law enforcement agencies to use any technique for acquiring digital evidence, let me say in broad terms, for any crime. And that was approved by a commission, and when it made to the Assembly, I filed an amendment to suppress that. And we started a negotiation, and in the end, that amendment that introduced this possibility for law enforcement of, let me say, a very lightly scrutinized use of technology for acquiring digital evidence was removed, and the government decided that they were going to introduce it in a new package about terrorism. And this package started in the Senate. So starting from that day, slightly more than 2 years ago, 2.5 years ago, I started working because this was coming, and I started working in order to present my colleagues an idea of a possible framework that tries to strike a balance between the expressed need by law enforcement and the government to do such things for investigation and the rights of the citizens. Because Trojans are not like any kind of technique of investigation that we have today. It's like everything together, bundled together. And it's done not directly by the law enforcement themselves, but it's done most often by private entities, private companies. And so it is much more sensible of what we have today. And therefore, we have in our constitution, we have a number of rights. And well, I'm not good in English at this, so I apologize. It's very technical on the legal side. So we have some principles in our constitution. For example, the home cannot be violated except in the cases provided by law. Conversations cannot be intercepted except in the cases defined by law. So the general principle is that they cannot be. But this thing, and these are regulated in the Constitution in different parts, and each of these traditional techniques of acquiring evidence in the physical world, let's say in the material world, have their own very well understood and very well scrutinized procedures and guarantees, etc. And then suddenly it appears this thing that bundles all this together and much more, because they allow Trojans allow to do much more than the existing techniques, and they have not a very clearly. So it's not a single principle in the Constitution. It encompasses many principles, and it's not so well defined in the procedures and etc. and the techniques. So we needed to try to bring this idea. Remember, it started with an amendment that gave a general possibility for digital acquisition of evidence without any specific thing. So to bring in some guarantee on the constitutional rights. So I filed an initial proposal, and then I started a working group where I called a number of experts. I asked feedback to many lawyers, Giovanni Battista, for example, here, and some other in the room. And after this nearly 2 years, because I'm not a lawyer and this is very technical, I'm a computer scientist, so I really needed help. I asked for help to one of the former speakers of the Chamber of Deputies, and we organized a number of interviews, etc. It was a very long work, and we proposed a number of changes to the Criminal Procedure Code, and so to define these guarantees and these possibilities, and we codified a number of principles, and we introduced in our proposal a new kind of action of technique of acquiring evidence, distinct from the pre-existing ones. This bill is a proposal, and I don't think that it's going to pass. Not because it's not well done. I mean, it's a huge work has been done. But last time I looked at it, there were about 5,000 bills proposed in the parliament, and 0.12% had passed. So this bill is not going to pass. But what we hope is that we, and by me I mean we, all the people who work to this, is that we are somehow defining a wider framework, not just specific, oh, well, this is like lawful interception. It is not. So a wider framework with guarantees, with techniques, and this wider framework has some principles, and we hope that these principles and these ideas that we encompass in this holistic framework can find place in the law that the government is prepared based on delegation by the Italian Senate. So I hope that the principle in this bill gets somehow taken into account in the work that the government is done. So this bill is not going to pass, but I hope these principles will survive, or at least it will define a way for how to do things. We had a public consultation on this for about 45 days. We had received a number of comments from Italy and from abroad. So even in the case the government acquires these principles, we already have some improvements that we know that can be done. So we're not done with the work yet.
Yeah, basically this bill is a first step to open a public debate and have everyone from the technical and legal side join in and talk about it. So, but obviously, like as Carol has said, this has been done everywhere, you know, not only in the US, you mentioned the FBI. This has been done in Italy and in other countries for a long time. So Giovanni, maybe you can talk a little bit about, you know, what are the legal issues at, you know, in play here? You know, if it's been done, so how is it been done if it's not like regulated? Can you explain, everyone?
Well, thank you very much, and thanks for the invitation to this panel. It's very interesting and very thorny issue. It has already been pointed out. It's not a totally new issue. We have already talked in 2008 at several conferences, especially a privacy, and I see many people who attended a privacy, about the Bundestrojaner, which is not only a German law in 2008, but it was also contested before the Constitutional Court in Germany, which introduced some principles which I think they are still very important before thinking about legislating or issuing any kind of law with regards to state Trojans. The German Constitutional Court, with principles which are quite similar with the Italian ones, or similar to the Article 8 of the European Convention on Human Rights, created a new constitutional right, which is the right of confidentiality of any kind of digital device. So this is very important, which is it's not only the domicile, as Stefan already pointed out, but it's more widespread. It's my device. It's not only communication, not only domicile, it's something more. And this is also, when I talk about Trojans, I always talk about, I also did it a couple of days ago at the national radio here in Perugia. I always talk about a very important decision of the Supreme Court in the US, Riley versus California, the decision which states that you need a warrant to search a phone, to search a smartphone. Why is it important? Because the decision states that, among the other things, the judges say that if a person or an entity from Mars would come in the Earth, maybe in Perugia, and take a look at us, he or she or it would think that this is a very important part of the human anatomy. And I think this is the first thing we have to consider when we talk about legislation. Let's come a little bit on technicalities. I'll try not to be too boring when talking about laws. Under Italian law, at the present time, there is no regulation whatsoever, but this doesn't mean that the use of Trojans is lawful. On the other hand, if the use of Trojan is not correspondent to any kind of piece of law in our criminal procedure, the use could be deemed unlawful. Another point is that we cannot consider that everything which is technically possible is therefore allowed. It's the other way around. There are strict rules for wiretapping, strict rules for interception of communication in the domiciles. If you cannot abide by those rules by using a Trojan, the use of Trojans is unlawful. So that's the first point. And it is very important, however, the effort done by Stefano, and even if it is not going to pass, and I have to agree with him, it is very important for 2 points. First point is that his bill is already shaping the way the tribunal, our Supreme Court is dealing with Trojans, because it has already been considered as principle before the Supreme Court. And the second point is that I'm sure that his bill also is shaping, as he already said, the bill which has been passed by one of our chambers on the 15th of March, which gives the government the power to issue a law with regard to Trojans. What are the main points? The main points of this bill, which I think this one is going to become law, is the fact that Trojans can be used only for very serious crimes, and that's the most important issues, and they have several limitations. The only drawback of this bill is the fact that it deals only with wiretapping of communications, not with the other aspects, like, for instance, remote search and seizures, which is a very complex issue. And it does not deal with other aspects which are still open for discussion. So what is the main point? And then I stop for this first round. What is the main point? We have I think, to change the normal approach to these technical issues. We don't have to think about what can be done, what can be technically done, because everything can be done. I think that Valerio will tell us that. But we have to think about the principle. We have to think about Article 8 of the European Convention of Human Rights. We have to think about our constitutional principle. And the first question we have to ask is the use of Trojan compatible, Trojan horses for investigation compatible with such principles? If it is not, then we have to find another way of investigating, maybe reverting back to normal investigation. In some cases, it is better, especially for minor crimes.
I think you made a good point that technically you can do everything, and maybe Valerio, you can tell us a little bit about how does this work in practice. Yeah, without going too much into details, because we've been talking about the laws, but how does this work, right? Like, can you walk us through?
Okay, thank you very much, Lorenzo, Laura, and Stefano, and Giovanni, to let me being here to speak about the technical side of the Trojans, because I think nowadays we always see in the newspapers, in the news, about the privacy, about the rights, But I think no one spoken about the real technical side except the technical articles about the researchers. I mean, speaking to the masses about the technical side and the issues of developing Trojans and how this applies with the laws and the regulations of the usage of the Trojans. As Giovanni said, everything can be done with a Trojan infecting a device. I can snoop on your emails and SMS and videos and whatever. The point is, even if everything can be done, why you are taking SMS instead of calls, instead of this and that? It depends on how the people who are in charge of using the Trojans use it. It's not about a Trojan is different by all the methods as wiretapping the phone line or entering your home and take pictures. It's the same. I think the point is the people who are the customers. Speaking about the companies who sell Trojans, are the customers, the law enforcement agencies and whatever, who buys these tools, the softwares. The point is how they use it, because you can tell the Trojan everything. You can tell the Trojan to take the emails but not the SMS. Take the phone calls instead of Skype calls. It's them who should use the Trojan within the limits given to them by the prosecutor office. I don't know the English term. Okay, so it's not really a point for me to differentiate the Trojan and the older methods of investigation. They are exactly the same, just the Trojan is new and is seen as something which is too, come si dice che viola, troppo invasivo, too invasive. Sorry, but my English is a bit rusty. The Trojan is new and is seen as too invasive, as everything new. When there's something new, is seen by the masses with suspicious. But really, it's the same as the old methods of investigations. The point is how the people use it. There's no really no difference technically.
Yeah.
There may be other issues, but no real difference.
Yeah, and you just to explain a little bit, because typically how these things work is that there's a private company that makes the tool, right? And then they sell it to a government. That's usually how it works. Some governments make them themselves. It depends on the country. So that's what you were saying with it depends who uses them at the end.
Exactly.
But I saw, Giovanni, you were like, saying no at some point. Would you like to, so why is it different? I mean, is it different or is it not different, wiretapping a phone call in the old days and using a Trojan?
There's a huge difference because from the moment that you can do everything, and I do believe in that, you can do different ways of invading people's fundamental rights with only one tool. That's the main issue. You can violate the communications. You can violate the domicile. You can attack different fundamental rights with only one tool. And not only not only that, but the tools follows the person, of course. As long as you have this one with you, you're at the same time searched, wiretapped, snooped, all at the same time, and all the people surrounding you have the same issue. And I think this makes a huge difference. Also because it's much simpler to do this than wiretapping like every room, every communications, every breath people take. That's a huge difference.
But if there's a simpler way to catch someone really, really dangerous for the other peoples, why? You don't want to use it in the name of, I know nowadays privacy, there's a bit of hysteria, in my opinion, about privacy nowadays. I always say that. I don't believe this is the path to follow, but this is my personal opinion. Why? If you have a mean of catching someone really, really dangerous, you don't want to do it just in the name of, but maybe they can snoop his email as well. You know, again, this is my personal opinion, but I think first we have to think about security nowadays, because this is a huge issue nowadays. Security, about terrorism, about everything evil in the world today. First, we have to think about security, and then we have to think about the privacy. This is my personal opinion.
Stefano, you wanted to say something?
Yeah.
Yes, I'm not going to enter in the debate of the hierarchy of values, if privacy comes before or after security and safety, because then you would need to look at the numbers, and the numbers tell quite a shocking story. I mean, recently I read an article where they compared two numbers, the number of people dying in the pools in California and the number of people injured in high risky nearbys in New York. And it's far, far, far more dangerous to go swimming in California. So there are many arguments. I'm not saying that this is correct or wrong. Perhaps I can just recall the fact that in Europe, in the European Treaty, we have one of the top principles is human dignity. And I'm not saying that this is correct. I'm saying that I'm not expressing an opinion of my beliefs. I'm just saying that this is the current framework that we have in Europe. And so unless we change the framework, that is the one that we have to abide to. I wanted to say two things. First, today is different, yes, because you have one single tool that allows you to attack different fundamental rights to one single person. And this is a fundamental difference. I remember, I'm old enough to remember when you had software packages where you had slide tools and word processors and spreadsheets all bundled into a single application, because that was what the market asked for. They asked for a complete package where you had all the tools all together. But then the market evolved, and you had specialized tools. And even more specialized, you have SPSS or Excel, depending on your specific needs. So what the market, the products that we have today, this is the point that I want to make, the products that we have today are somehow the meeting of the requirements of the market and the offer, the requirements of the demand and the offer of the supply. But that is not heaven sent. We can change that by effect of regulation. So for example, deciding that we can have different tools with different procedures, different methods, different authorization paths, because it might have, and that would create even a larger market perhaps, but very much more professional than the one that we have today, when it's all, well, I'm not saying that it's not professional, so, but you get the idea. So what I wanted to stress is that the tools we have today are the market effect of the meeting of demand and offer, and that is not heaven sent. That can be changed by effect of regulation, first. Second thing, I wanted to clarify on the point that Giovanni Battista said before. So I had my proposal file, our proposal. I must thank Fabio Pietrosanti sitting here because he gave an invaluable help, and many others, so I don't want to, Stefano Terno, but I mean, Luciano Violante, and many others. I had my proposal, our proposal presented at the Chamber of Deputies. And then at the Senate, there is this law that delegates the government to pass a law that says how these things must be done. And it's not as comprehensive as the proposals that we made in the Chamber of Deputies. Is much more limited. So the government will have the chance, the obligation, given that the Senate gives this delegation to the government, to come out with a bill that covers a part of this aspect, not, for example, remote search and seizure. And the government must abide to the delegation given by the Senate. So they must stay within those limits. This does not guarantee that after the government prepares his proposal of bill and it goes back to the parliament says, okay, this is good, but you have to attach remote search and seizure as well. Okay, so the process that we are in now is giving a more limited scope than the bill that I'm proposing, but that does not say that when this bill prepared by the government will emerge from the parliament again, it will be much more comprehensive. I believe that it's going to be much more comprehensive because I know the talks that are undergoing. So something else, I believe it's going to be attached in the parliamentary debate that it's going to come afterwards. The government prepares his schema of decree. So the thing I am on myself personally now is trying to explain to my colleagues in the Senate that even in the part that they are not covering now, there are some principles that should, in my opinion, and should be borrowed by our proposal, and I'm trying to explain them these principles. So some of them are already incorporated in this part that the Senate is given the power to the government, and I hope that another part of them will be incorporated in the ongoing development of what will be a more comprehensive bill. In any case, the fact that we made this work has already produced some efforts, some effects, as Giovanni Battista recalled. And so let me say that a small step ahead a significant step ahead with respect to the proposal that was passed in the Chamber of Deputies in the amendment in the committee that gave broad powers with no guarantees. Well, it was a significant step forward.
I think we haven't really explained how we got here, though. Like, why do we need to attack or hack a specific device? Maybe, I don't know if Carola or Valerio want to explain this, but I think that maybe someone in the audience is thinking, like, why do we actually need to go after a specific device and not, why can't we do just wiretapping like we used to do before?
Well,
I know that this sounds like an obvious question, but like, I think we need to.
Maybe, yeah.
Like.
Well, nowadays there's the need to hack a device because, fortunately, from the privacy side, all the communications are encrypted. So, in the past years, you had to wiretap, you had to intercept phone calls. You simply go on the wire and tap the wire, and that's all. You have the voice calls. Nowadays, you have Skype, you have WhatsApp, you have Facebook, and whatever. Everything passing on the network cable is encrypted. So you have to find a mean to get the information before it is encrypted and on the other side, get the information after it is decrypted. That's where the Trojan makes possible to intercept, for example, VoIP calls with Skype or WhatsApp or whatever. The same for encrypted chats with Skype or whatever. The chats, the messages before leaving your device gets encrypted. So you have to install something on your device, or on the target device, which takes the information you send out before it is encrypted by the operating system, and which gets the information after they are decrypted by the operating system. For example, the message you see on the screen. That's where without Trojans nowadays we can't intercept communications anymore, because I think 90% and more of the communications nowadays runs on encrypted channels.
Carola, did you have a question or you wanted to?
I agree. I mean, I don't know if you ever saw also the advertisement, the marketing from some of the companies. If you remember, they are saying, like we can bypass encryption. I mean, we go directly to the source. No? So the encryption, of course, it's a way to, it's a workaround to get, encrypted communication. But on the other hand, it's much more than just wiretapping. It's not, I mean, it's a workaround because wiretapping doesn't work as much as in the past, but you get much more than wiretapping a phone conversation. And that's the whole point of all the discussion. Actually, I just wanted to say one thing, that it took something like 15 years to have this conversation. And I find this amazing, like, for me as a journalist, it's just, I've been amazed by the fact that for many years, it has been so difficult to understand something about what was going on in this field. I didn't know you, but now I will. And for instance, like we didn't know much about the producers, I mean the companies producing them. We didn't know much about the employment, because you can produce a software, but then you have to employ it. And as Valerio said, the employment is very important. It's very important. It's crucial in a technology. We didn't know about for which crimes were used against. At least in Italy, it was not clear. I mean, just mafia and terrorism, no, maybe others. I mean, for what we've seen, So we didn't know much about the software that was used. And still, I think the proposal and the effort made by Stefano Quintarelli has been very important, because for the first time, someone also from in the political world tried to address at least some of all the questions posed by this technology. And also, I would like to add another one. How do you preserve evidence and material kind of collected that maybe is not even so relevant? How do you preserve it also from potential leaks? Because we know that the wiretaps often leak on media, leak around. How do you preserve maybe more sensitive information you can get from leaking that could be devastating also for someone? So yeah, I have a question. I don't have answers, but as a journalist, there have been a lot of questions for many years.
Can I jump?
Yeah, of course.
One more issue, which I think is very relevant, is the issue of jurisdiction. Because with the Trojan, you can, for instance, of course, snoop all the passwords, and then gather all the data from an email, from any kind of cyber locker or whatever, which is not situated in Italy. May seem strange to you, but we still have theoretically very strong national limits on on the way our prosecutor work. So this is a workaround. Instead of going through the usual and correct channels, you take a shortcut, you grab the passwords, you get every kind of content, and voila, it's done. Well, but you are violating several key principles of jurisdiction and territoriality in criminal law.
Well, you are also stupid because if the target activated two-factor authentication, he will get the SMS.
Yeah. But you can. I know you can also overcome that. So, but just by grabbing the device as well.
So what's the? I mean, what is the ideal outcome of this debate, in your opinion? Maybe we can, like, how do we balance privacy and the need? Because I mean, we all agree that police departments and intelligence agencies need to use these tools. How do we balance it? How do we balance them?
If I can say it, it's very complicated. Just read my bill and trust me, it can be improved. I mean, it took me 2 years, not working 8 hours a day on that sort of thing, but an elapsed time of 2 years trying to understand and learn of all these things. It's really very complicated. This is not going to end here. So it's something that we must bring into the public debate. And journalists that write about this are very valuable because they help raising the awareness. And then philosophers should come in as well, and sociologists. And I mean, it should be a wider debate, not just limited to lawmakers, prosecutors, and technologists. I mean, it's something that is wide for the whole society of us to deal with.
Valerie, you've worked in this. Like, how do you think we can improve, the use of Trojans, or how would you limit it?
Making it compulsory.
Make them more effective.
Well, improve the use of Trojan. As I said, the weak point is who use the Trojan. Because if you look at the difference between NSA, for example, or those agencies who develop the Trojans is an active part in installing the Trojan, in controlling the Trojan. What happens with companies who develop the Trojans and then sell it to law enforcement, to Polizia and Carabinieri, for example, in Italy? You completely lose the control of the Trojan, and it's easy to say, oh, but they are doing this. They are developing this Trojan, they are evil. No, it's who is using the Trojan, which is to blame many times if the Trojan lands on a journalist device. It's very hard to regulate this because the producer completely lose the control of the Trojan.
Stefano?
It's not
Just a quick comment on our proposal. Law enforcement agencies, so the legal part of the users, have very well-defined methods, procedures, techniques, etc., trackings, logs, blah, blah, blah. So that helps dealing with what he was saying before. There is another, it's not directly related to our proposal, but there is another whole area of things that we need to think about, and I don't think that I'm going to be able to work on that by the end of the legislature. I mean, it's perhaps yes, who knows, but it's the control of the sales of these technologies, because these are dual-use technologies, so that can be used for good or for bad. And we have, it's easier to track the sale and the usage. It's not simple, but it's easier, of guns. This is much more complicated, and in my opinion, soon we will need to start thinking about some way of defining in a more appropriate way, specific to this kind of technologies, how they should be treated in terms of sales authorization, reporting, auditing, and these kind of things, so that part of the effect that he was commenting before, we can address part of the effect that he was mentioning before. Law enforcements are covered. The problem is the rest of the world.
Yeah, that's important because like companies like Hacking Team or others, they don't only work in Italy. They sell all over the world. And so I guess what is the role of countries that host these companies? Should they stop, should they regulate the sale of this, and how do we regulate this sale? Is export regulation the answer? I don't know if Giovanni, maybe this is not like your specialty, or maybe Carla, but what is the role of export regulation?
The point I was making is that perhaps export regulation is not enough.
Yeah.
Okay, because take guns, for example. Sales of guns is regulated even internally, not only the export. Okay, if I sell a gun to a private individual in Germany, that is tracked. Okay, the use of this technology, if I sell to somebody within the European Union, well, maybe. Within Italy, not for sure. So what I'm saying is that we need to have a more holistic view of the process of the commercial side of these things, in order to understand if something can be improved or made it more transparent in case there is a need that it needs to be audited, and so decide by whom, etc. So it's separate from the regulation of Trojans themselves, but it's also a big issue that I think it's going to emerge because the market is big.
I mean, it's difficult. It's really complicated. And at the European level, there has been a growing awareness of the issue. And so since 2013, the European Union updated its regulation on export control and included, like intrusion software, so Trojans, in the dual use technologies goods. And now actually they are working on another update of this regulation because they realize that the problem is really how it's been then applied at the level of the member states. And also they are trying to include the human rights side in the consideration when you have to decide to export technology. I mean, it's more like a principle things in a way because of course, Europe can go in one direction, and some other countries can, still do the dirty job. But at the same time, it's a sign that can also put pressure on, on other countries. Or, of course, it's not something that you solve just with, an export law or an export control, because actually there is also a huge market of. I mean, this is connected, but another topic. There is a huge market of, this kind of software and exploits and so on. So, of course, it's very difficult.
We haven't talked too much about the cases where these tools were used against, like, human rights defenders or journalists. There's been a lot of examples of that. I guess the question that some people might have is, why do we know about the cases where, it was used against good guys, and we don't know about cases where it was used against bad guys? Should there be more transparency in, like, should we know about good cases where, this has been used?
Well, probably maybe Stefano can speak better than me about this, but of course, on the press, on the press, we see always the cases where the Trojan has been found on the device of the good guys. But of course, they are used for real cases of very, very evil guys. Of course, I worked for companies. I don't know exactly, of course, because we are not supposed to know to who the Trojan is installed. But of course, for the safety of the
investigation.
For the safety of the investigation, of course, you don't know many times that an evil guy is taken, is captured because of the Trojan, but they do. On the press, you see about the Trojan found on the good guy's device, because I said, again, my personal opinion, because today there's a bit of hysteria on the privacy subject.
Yeah, but I mean, no, I mean, obviously, so why don't we, like, I understand why the government doesn't want to talk about it.
I don't know, I'm not a government.
Yeah, no, like, I understand why developers like you don't know, you develop a tool and then someone else uses it. But
of course,
Giovanni, like, you can talk about, like, why does, I mean, this should end up in court somehow, right? Like, if I'm the government, I use this tool and I catch a terrorist, eventually this goes into a court. But we haven't seen a lot of these cases. And why not? And do you think it's going to change?
Well, as Carola pointed out in the first round, first there was, I think it was clear that they didn't want to talk about it. But if you see at the cases where a Trojan is involved at the present time, like the Grand Chamber of the Supreme Court of last April, which issued a landmark decision, or the other 27100 of decision always from the Supreme Court, or some other decisions, they are always regarding organized crime or mafia. So these are not exactly the good guys, so to speak. But I have to tell one thing on this point. Fundamental rights don't make a difference between good guys or bad guys. In a sense, of course, the balance is changing. The balance is shifting. When you have a very serious crime, the fundamental rights may go lower in the scale, but they still do apply to everyone. So in the cases, the main cases before the courts always are related to, as I said, mafia, terrorism, or organized crime. But let's think about even the very concept of organized crime. Organized crime in Italy would be, for instance, 3 guys who decide to hack several sites. If you apply even just for fun, just for the fun of it, not for doing any damages or things like that. If you apply the principle stated by our Supreme Court in the Grand Chamber on Trojans, theoretically you could use a Trojan for that case as well. So at the present time, several cases regarding bad guys, but this is, I think, it's not a key issue.
Carola, did you want to say something?
No, I mean, not on this specific, I mean.
Well, maybe why don't we go around and say one last final point before opening up to questions. What do you think we're missing here, Stefano? What do you hope is the first step that we can achieve towards more change?
Well, I believe that we have already achieved the first steps, that many of the principles that we proposed in our bill are now incorporated in the delegation that the Senate has given to the government. So that was our part. The second step that we need to achieve is that when this debate will come back to the Senate and the scope of the bill will likely be broadened, also other principles should be incorporated. And and we will make some proposal of amendments and all the things that we have to do in this case. I believe this bill is going to pass because, I mean, it's a delegation to the government, and it's very likely that the government will stay in charge enough time in order to have this bill done. And so we need to keep an eye on the work and make sure that our position is listened to.
Yeah, Valeria, do you have anything else you want to talk about?
Well, we haven't talked about the bill itself. We talked about everything in general, but we haven't said anything about the bill itself. I wanted to say something about the bill, which is, in my opinion, most of it is okay. So you did a very good work, even technical. But there's, sorry again, but there's some just 2 or 3 points that I think that technically they are not feasible at all. For example, there's one point which states that the Trojan should not lower the defenses of the operating system of the device, and by design this is not possible. This is, I think, the worst point in this bill. Everything else, more or less, with a bit of adjustment, is okay. But this point doesn't make sense at all. How do you install a Trojan which bases itself, its functionality, many times nowadays on a vulnerability of the operating system without lowering the defense of the operating system? Oh, Federico. Sorry. How do you cope with that? It's by design impossible.
Yeah, maybe. Yeah, can explain why you put this?
No. I don't want to enter in arguing into the details because you need to look at the interpretation of that sentence. Of course, you should not lower more than it is now. So it's so that's the meaning. But I was going to say, this is a very complicated thing. It introduces about 15 or 16 principles, and if there are just 3 details that he does not argue, that does not agree with, I must say that I am much more in disagreement with my wife normally, and I have married her. So it means that we really made a good job because, of course, anything you propose, making a proposal means suggesting a change. And a change, by definition, is going to discontent someone. And if you discontent very little everybody, well, that's a good sign of good job. So thank you for your comment. Gentlemen, I have to leave. Thank you very much for your time. I have to catch a train.
Okay.
Ciao.
So I guess maybe we can open it up to some, well, let's give Carola and Giovanni, yes, and then we can open up to questions.
Yeah, I wanted to, because I just wanted to introduce a little bit of pessimism, because, I mean, the law, the proposal is very, it's good, and what I'm afraid of is the fact that, okay, anyone in Italy who is doing investigation today has been used to use these tools and will want to keep using them more or less, possibly in the same way. Also, we are living in difficult times, of course, because there is like concerns for terrorism, and this also is going to play. So what I will expect will be a sort of, like resistance from some sectors in order to introduce more, guarantees. So if you think that this is an important issue, and I mean, you should keep an eye on it, because it won't be easy to regulate it in such a comprehensive way as the intention was. So that was just a note that I wanted to add. Yeah.
Just one very short comment. I have to tell, it has already been pointed out that making people aware of the issue is very important, is a key factor. And I think this is true also for judges and prosecutors. I have several occasions to talk with them in several congresses, seminars also, especially for the prosecutors and the judges. And sometimes I realize that they think that it's just another way of doing the old wiretapping, search and seizure work. And I know that Valerio doesn't agree, but it's totally different. And even only if this issue is clear, just is something way more invasive, which has to be regulated in a different way, in a stricter way, this is maybe gives us some hope for the future. I don't know if I think I really hope I am right.
Maybe we can open it up to questions. We also have here Fabio, who's worked on the proposal. So if anyone wants to ask anything, someone, yeah, the microphone is going around.
Thank you. Thomas Dani, thank you for this panel, this discussion. We in Netherlands, we have a bill for the state hacking. There is now pending before the Dutch Senate, and one provision especially talks about the 0 days vulnerabilities that must be disclosed after the usage by the police. And this is really a big thing, and I kind of think that this is not going to be the same text that will be approved by the Senate, so maybe we won't see this provision anymore. And I don't know how this provision will be effective on the cases when the investigation are carried out by private companies. So they're referring about law enforcement agencies and police. So maybe if it's demanded to third parties, the investigation, this provision will not apply. But this is not so clear yet. But what do you think about it, and what if? Just curious if this provision is also in some other texts, or I don't know.
Yeah, just before we answer, just for who doesn't know, 0 days are basically unknown bugs and vulnerabilities in software, unknown to basically the company. So let's say maybe a 0 day in Facebook is a way that someone can hack into Facebook and Facebook doesn't know about it. So these are used in investigations because that's how like police departments or bad guys or anyone gets in without anyone knowing. So the question is, yeah, like what? Yeah, no, like
I just want to thank you for the question the first time. Have I heard right that they proposed a 0 day to be released after the investigation is done? Okay, yes, you kill hundreds of companies who works on 0 days. You know that there's like a black market about the 0 days. A 0 day can cost $1 million nowadays. So I don't think it makes sense at all. Well, it's not your fault, of course. It's but
Carlo, Giovanni.
You also are going to compromise investigation of other states.
Sorry?
And you are also going to compromise investigation of other states if you disclose.
Of course, it's completely crazy.
Do you guys want to add something, or we have more questions?
If I may add on this, with regards to the proposed bill, it's explicitly stated that only law enforcement and prosecutor can operationally work to inject and operate the Trojan, while actually almost all private contractors do that. And as a second aspect, during the law proposal development and the meeting with law enforcement, prosecutors, and so on, what we learned practically is that 0 day, even if are very interesting from a scientific and security point of view and create a very big hype and concern worldwide, are used almost, I mean, are never used basically, because 99.99% of the Trojan injection happen through physical possession of the devices or through social engineering. And as a third aspect, law enforcement, typically for their average uses, I'm not speaking about intelligence or massive international operation that are a niche of the uses of the Trojan, but law enforcement, general operation, that just doesn't have the budget to buy it.
Yeah, any other questions? Any thoughts? You had
well, just to reply to Fabio, what the customers wants and asks 90% of the times is remote code execution, so using vulnerabilities. So, well, in the reality, you are right, many times they rely on a physical access to the device, but what they ask for, and if they can, they use it, is remote infection with the sorry?
Yeah, can
you have to use this does not mean you have to use a 0 day. You can use an all day, 1 day old.
No. It doesn't mean that. In my opinion, I'm against 0 days. In my opinion, I'm against the usage of 0 days. I've always advised to not use 0 days because, in my opinion, it's completely crazy to spend millions of dollars on something that the next day could be burned. So from the company perspective, acquiring a 0 day is a bet.
Is a risk.
Is a huge risk because okay, if you can buy a 0 day for $30,000 is okay, but if you have to spend $1 million in a vulnerability, in a chain of vulnerabilities, which may cost even more, $2-3 million, and the next day the vulnerability is patched, we are talking about a huge amount of money. But nevertheless, this is what the customer many times, well, all the times asks for. They just want a big red button. In fact, okay.
I have another question. Are there procedures in order to be sure that intercepted data are stored and handled in a proper way on all the sides, on your side, police side?
Speak slow because my English is. I speak a good English, but I can't. Okay.
Are there procedures nowadays in order to monitor how the data that you have acquired or the police has acquired are handled during the investigation? There is a life cycle chain of custody for the life cycle of the information. What I want to know is it's a safety procedure, so where are the data of the people who is the target of the investigation are on the third-party company servers, are on the police server, where are such data?
It depends on the customer. Usually what the company producing the Trojan offered to the customer is a solution which gathers the data with the Trojan and uploads the Trojan to a server, which may be here, which may be in another state, which may be at your home or in the office of the prosecutor. This is up to the customer.
Do we have to care about the fact that, for example, you install a Trojan on my iPhone and my data will be stored in Iran? Is this safe? Is this something we have? We need
it's better that Giovanni answer about this. It's not my job.
Okay, this is a huge issue, also because, of course, you cannot store it directly in the servers of the public prosecutor. You just take a look at the traffic. Oh, why my phone is talking with the IP of the public prosecutor? Oh, maybe maybe I have a problem. No, you know, it's kind of easy to understand that this is not directly possible. At the present time, it is a huge issue because with our present criminal procedure code, you theoretically can use third-party services when it comes to wiretapping of communications, so not wiretapping of conversations or voice conversation, but of data. And this is a huge issue because theoretically you can kind of outsource the wiretapping business as a whole. In the bill, the one which is going to delegate the government to rule the matter. So but also in Quintarelli's bill, it is stated that the data have to be stored in the public prosecutor servers. So this is kind of guarantee. Of course, they cannot be stored there directly. It's always impossible. And also you have to keep track of the chain of custody. But at the present time, this is a big issue for ongoing cases.
Yes, I think there's a question. You have a question? Yeah, here in the front, please.
I mean, it's a question I wanted to ask to Quintarelli, but I guess Giovanni can answer that too. So at the stage we are now, and my name is Antonella Napolitano and I work for the Italian Coalition for Civil Liberties. So we've been following the developments on these issues and also on the export control regulation. So at this moment, when the law delegates the government to write effectively how this is going to work, and they have to do by like 90 days, if I'm correct. At least that's what I heard. But what is the process? And then when it goes back to the parliament, what happens? Because we've been seeing a lot of big issues that needs to be addressed. We know that there are constraints, but we don't know how the process works. And so how do we know the process to write? How can we know what are the issues, and how can we try to ask for something different to be done to address the parliament as civil society of all these concerns, the one that were highlighted and others we might have?
So the process now, of course, it has to be also approved by the other branch of our parliament. And then the government will, when they finally have the draft legislative decree, they will send it to the parliament for an opinion. And then they will finally approve the legislative decree. The point is that the legislative decree, the law is already quite precise on the issues. So I think that more or less the legislative decree will be a copy and paste of the delegating law, more or less, because it says several principles, for instance, also the certification of the software which has to be used for infection, for Trojan infections. So I think that we can start by taking a good look at the law which is going to be passed. And I think that the key issue is the one we mentioned before. This law regulates only the remote activation of the microphone, not the other functioning of a Trojan. And this is a big issue. This doesn't mean, this may mean two things, just as a lawyer. Means that maybe the legislator thinks that the other uses are unlawful, or maybe it thinks that they may be lawful under the current umbrella of the criminal procedure code. So I think that for the first approach would be to take a good look and criticize the main point which have to be criticized of the bill.
But can I ask a follow-up question? Does it create a loophole? So if it's not stated that it's unlawful, can it be, I mean, it is lawful, or it can be,
the answer is perhaps. Because, because one point, for instance, with remote search and seizure, which is I think the most complex issue, our Supreme Court, in a case which dates back to 2009, stated that it was lawful because it was only a way of getting some files from a PC, more or less just like grabbing some pieces of paper from a desk, and that's about it. But of course, the court didn't even have understood how different the system is. So maybe now the case would go in a completely different way, but still you cannot find a definite answer.
Well, sorry, just a presentation. Well, what's the point of this lawful and unlawful about the Trojan can capture the microphone and the SMS and whatever? You can do a Trojan that captures only the SMS and sell this to and send and infect the target with this. What's the problem about it? That there's really no problem. It's not that a Trojan captures everything. You have a Trojan on your iPad, and all your iPad is. It's possible, but again, if the prosecutor office decide, okay, you have to capture only the SMS, you configure the Trojan with just the SMS without any kind of code related to capture the microphone and whatever, and that's all. Why not?
So you're saying that it's technically possible, but
of course it's technically possible, and it's done this.
But
it's done this way. It's done this way.
That we need a law in order to enforce this.
I give you a very simple example. Assume that you need to collect WhatsApp messages. Now, from a juridical standpoint of view, and so the right point of view versus the technical are two completely different aspects. If I need to collect the messages that has been stored before the prosecutor authorized a warrant, it's a search and seizure. I'm acquiring a file from the device. If I need to intercept the messages that are coming after the prosecutor authorized a warrant, it's telecommunication interception. The technical routines that does the collection always read the same piece of file on the disk, but the juridical authorization are completely different.
Okay,
so and there's no way to prove that the tool were doing only X or epsilon.
Okay, so if a very, very bad guy is infected by a Trojan, and the very, very evil messages are 2 days before the prosecutor authorization, and you capture those evil messages, in court, the very, very bad guy can tell This is crazy, in my opinion, but okay, I accept it.
You're making investigation in order to assess that. You're making investigation in order to acquire information and to acquire evidence, and then there is the rule of law, because you are assuming that all the guys that are intercepted
I'm just a developer, so
but this is why
I'm used to think logically. If there's a very, very evil guy which is intercepted by a Trojan, I wouldn't mind if I captured his messages 2 days before or 2 days after. This is logic. If
the law is not made only for the bad guys. The law is made to apply to everyone. So the guarantees are the same.
And okay.
No, it's one point.
Yeah, maybe Giovanni, you can.
Sorry.
Yeah, no, please.
No, just one point. Once again, citing Riley versus California. Riley versus California stated that you need a warrant for searching a smartphone, and the judges said, in a very pragmatical way, it may seem strange because if they have an evidence on the phone, like the records of the company which is going bust, the true record, not a false one. If they had it on paper with him, the police officer could just have grabbed them, no problem. Because it's there on the phone, you need a warrant. And if this passage allows the person to delete that evidence, well, that's a problem, but still general principle and guarantees sometimes come before then getting the work done.
Maybe we're almost done, so maybe one last question, if there is, and we can continue the discussion later if there are no more questions. But I think it's... Any last thoughts?
Couldn't you just use a keylogger application if you have to track the data after a certain date instead of grabbing a file with everything inside the phone?
Everything is possible. It's just up to who use it. Again, the problem with all this history about this is how these tools are used, not what these tools are.
A small question for Valerio. Did someone of the past customer ask to review the source code or to run the infrastructure internally because they were not trusting your companies?
No.
Okay.
No.
Any last thoughts? Maybe for Carola, you've been silent lately. Do you have anything else to say, or?
I think we said most of the topic.
Yeah.
I mean, we didn't finish.
Yeah, there's so much to talk about. Yeah.
Just a point that I invite anyone that is interested in going operationally and also technically and partially legally to look at the recently published equipment interference rules of engagement. The equipment interference is the article of the UK IP bill that allow the use of Trojan in the UK. Now, the equipment interference rules of engagement, it's a deeply operational and technical document that basically say how and what the different kind of law enforcement, militaries and intelligence agencies of UK can, how can use the Trojan. And if you read it operationally, basically you horrify because it say that you can do everything, including catch all, install the Trojan on thousands of persons, and then let's see who is the person we are looking for, etc., etc. This is the very bad example from the privacy perspective.
But that's not how it is intended. The usage of these tools is not intended for this. Again, it's the people who misuse this. If I would install a Trojan on someone, I will never use phishing campaigns or whatever I heard they use. You have to target a guy and install the Trojan only on that guy, and of course, it happens that you may install the Trojan on his wife, for example.
Yeah, that's interesting,
and
actually.
This poses another question.
It has already been done.
But not using a phishing campaign to, as we say in Italy, in docoio coio. This is completely a stupid usage of Trojans.
I don't know how to translate that, but I think we've established that this is going to be very hard, but also very interesting. If you guys are interested, you can ask us questions later and check out the law that's been introduced. This is, as Stefano said, and as everyone said here, it's a very important issue, and we'll have to talk about it. So thank you so much for coming and listening. This was very long, I know, and a very complicated topic, but thank you very much. Hi everyone, thanks for coming to this panel. I'm Lorenzo Franceschi-Bicchierai. I write for Motherboard, the tech and science channel of Vice Media. I'm really excited about this panel. We have a lot of things to talk about, so hopefully we can go through the main issues, and since this is a very complicated topic, I hope that we can open it up to everyone to ask questions, and no question is too stupid or simple, so please feel free to ask questions, and we'll try to keep it friendly here, and all of us can jump in whenever we want. Just as a little bit of an introduction, we're going to talk about basically how governments hack, how governments use hacking. Some people call it lawful interception, some people call it spyware, Trojans, surveillance technology. It's all part of the same thing. So in practice, we're going to talk about how governments use hacking techniques and software in the course of intelligence and criminal investigations. So we're not going to talk about the classic cybercrime, teenage hackers stealing credit cards. We don't care about that today. So this is a thing that it's been going on for a while, I think 10, 15, maybe 20 years. Governments around the world have started using hacking to catch criminals, terrorists, and others. But for many years, the public hasn't really known too much about it. In the last few years, we've known a little bit about it because of public research into companies that sell these kind of tools. For example, the famous hacking team. And so we've seen a little bit about how these things work. Also, we had obviously the Snowden revelations, which gave us a little bit of a window into how the US government does this stuff as well. So why do governments...
Investigation, and it came out that, they use it. But actually, I have to say that the interest really grew after the leak of hacking team, maybe because it became so mainstream that all the different aspects of the issue, because as you said, it's a very complex issue because it has different angles. Of course, in the last years, it's been covered a lot about the use of these tools to, especially in foreign countries, like in non-democratic countries, and this is like an export issue. But then you also have the use in democratic countries. How do you intend to regulate them? Because and now we have a lawyer, we have a legislator. We know that they have not been regulated really at all. There's a sort of a limbus, not really a defined status. So yeah.
Yeah, I think the regulation is a very important point, and you mentioned Germany in 2011. I think Germany at the time became the first country to pass a law that specifically talked about Trojans. I think they called it the Bundestrojaner law. Yeah, and as far as I know, very few other countries, or maybe no other country has a law specifically that talks about Trojans. And Italy wants to be the next one. So maybe, Stefano, you can talk a little bit about this proposal that you guys have, and basically tell us a little bit about what you want to do and why now.
Okay, thank you for having me here. Well, effectively, grazie. Effectively, slightly more than 2 years ago, sorry, I have to apologize. I have a train to catch, so I will have to leave 15 minutes in advance. I apologize with all of you guys. Something more than 2 years ago, there was an amendment passed in the Chamber of Deputies which gave essentially the possibility.
Hacking, we're going to talk about that, and we're going to talk about how encryption technologies and the rise of high-tech encryption technologies has pushed governments to do a little bit more hacking. This issue has obviously two sides, the technical and the legal side, and luckily we have here people that know a little bit about both. We have a tech person, a lawyer, so we'll hopefully talk about both. And obviously this is a very timely moment to talk about this, because some Italian parliament members have introduced a law to regulate hacking in Italy. So we'll talk about that too. But first, let me introduce my colleagues and friends here. We have Stefano Quintarelli here. Quintarelli, I don't know how to pronounce it in Italian or English. Anyway, he's a Scelta Civica member of the Italian Chamber of Deputies.
That's a fake news.
Fake news, great. A graduate in information science from University of Italy, of Milan, sorry, and he's one of the pioneers of the internet in Italy. We have Valerio Lupi here. Valerio has worked as a developer of government surveillance software or lawful interception since 1998, which sounds like a lot of time ago. He's a former rootkit contributor, which at the time was the reference website for what people call now advanced persistent threats, or APTs, basically like high-level hacking. We have Giovanni Battista Gallus, who is a lawyer specialized in copyright, criminal law, data protection, and privacy. He has a European certificate on cybercrime and electronic evidence. His resume and curriculum is probably too long.
And too boring as well.
No, not boring, but too long to go through. And we have Carola Frediani, who is my colleague, journalist from La Stampa. She's also the co-founder of the media agency F5, and she has written basically about all, she's written about hackers and all kinds of spyware and surveillance stories. So thank you all for being here. But let's start with the obvious question that probably everyone has, is what is government hacking and why is it controversial? And maybe, Carola, you can start telling us a little bit about that.
Yeah. Oh, thank you, Lorenzo. Lorenzo, did you present yourself?
I did.
Okay,
I'm just
okay. Lorenzo, yeah, is also covering a lot this topic. So, yeah, as you said, it's been for many years government has been using these tools. I mean, but we really knew little about them until a few years ago. And I think there's been like a public instance of this. It was around 2001 when we talked about, remember Magic Lantern? This was the code name, the name given by the media for an FBI tool trying to capture, passwords. And then later on, much later on, really the topic came out. I think the year was 2011. It has been a kind of crucial year for the public awareness, because we had the the Chaos Computer Club found evidence of a Trojan used by the federal government and in Germany. In Germany, the Chaos Computer Club is this, well-known hacker groups in Germany, and at the same time, WikiLeaks came out with these spy files where some producers were named among other surveillance or lawful interception companies, and also in Italy we had maybe for the first time on the mainstream media at least there was the news about this tool being used for a specific inquiry. It was, if you remember, in the so-called P4 for the Italian, investigation.
To law enforcement agencies to use any technique for acquiring digital evidence, let me say in broad terms, for any crime. And that was approved by a commission, and when it made to the assembly, I filed an amendment to suppress that. And we started a negotiation, and in the end, that amendment that introduced this possibility for law enforcement of, let me say, a very lightly scrutinized use of technology for acquiring digital evidence was removed, and the government decided that they were going to introduce it in a new package about terrorism. And this package started in the Senate. So starting from that day, slightly more than 2 years ago, 2.5 years ago, I started working because this was coming, and I started working in order to present my colleagues an idea of a possible framework that tries to strike a balance between the expressed need by law enforcement and the government to do such things for investigation and the rights of the citizens. Because Trojans are not like any kind of technique of investigation that we have today. It's like everything together, bundled together. And it's done not directly by the law enforcement themselves, but it's done most often by private entities, private companies. And so it is much more sensible of what we have today. And therefore, we have, in our constitution, we have a number of rights. And, well, I'm not good in English at this, so